So good morning everybody. Our first session is about managing litigation in today's industry, which could cover an enormous range of topics and is what we all spend most of our lives worrying about. We've got three excellent speakers. Our first speaker today is Abhijit Mukhopadhyay. He is the President of Legal and the General Counsel at the Hinduja Group, which is I suppose best described as a classic multinational conglomerate, isn't it? It's an amazing history of a company. It's existed for over 100 years. It was founded in Mumbai. For a long time, it was headquartered in Iran before it moved back to before it became headquartered in the UK in 1979, which was probably not a great time to move back to London, but London at least has improved somewhat since then. It's a very, very substantial company, some 25 billion of turnover. Abhijit himself, his CV is something that I would certainly envy. I would love to have. He's had senior positions in some of the best-known companies, Dunlop, Ranbaxy, Suzuki. So we're very honoured to have him here today. Our second speaker, Ibrahim Yaku, is Associate Counsel at Salona and Akpana in Nigeria. He was called to the bar in Nigeria in 2009. Not only does he look like a Hollywood movie star, and when I arrived this morning, sweaty and a little dishevelled from my cycle ride from Waterloo, to be confronted with Ibrahim, I thought, damn, I'm old. But not only does he look like a movie star, he also lists on his list of practice areas, his first thing he lists is intellectual property, so he must be a good chap. And our final speaker, Maria, needs no further introduction, so I will hand over to Abhijit. Thank you.
Thank you, Richard. Good morning, ladies and gentlemen. As Richard says, I represent a very large group, 90,000 people in over 40 countries with 10 business verticals. However, to us, dispute, arbitration, litigation, we don't like it. Are really very, very bad words. I don't want to use the word dirty in the morning itself, but then it's a very bad word as far as we are concerned. The reasons are quite well known. Some of them Maria in the morning has already mentioned. Why we are dreadful about disputes? Because it costs money. I know there are many outside lawyers, external lawyers sitting here, but I don't want to spend any money for fighting a dispute and giving it to the external lawyers. If I have got the opportunity, I will avoid it. So it costs me. I bleed when I have to pay money for fighting a dispute. It costs me time because the disputes are of different varieties. I have handled disputes which went on for 3 to 4 years. It's an intellectual property dispute in Estonia, and if I've got time, I will try to touch base on that. Then there are disputes which are multiple in nature. It goes on in different countries around the world. At any point of time, we have got very strong IPR. There are IPR disputes going on in no less than 20 countries around the world. Gulf Oil is one of the group companies, and it has got a very strong global brand, and I am fighting IPR disputes in no less than 20 countries around the world at any given point of time. So you imagine the time of managing those disputes. Then we have got one-off disputes where strategy is involved. So the nutshell is that what Maria has said, I can't more than agree. Time, money, efforts, but most importantly, and that is where we are extremely worried, I will lose my customer. I will lose my joint venture partner. I will lose my friends. I will lose my potential business partner or potential customers, although I may win a case. And that is really dreadful for a very large business group like us. There are plenty of examples I can give. There is some time back, we had a big dispute with Sumitomo. It's a very large business group. It's bigger than us. And eventually, in the midway, surprisingly, I had a talk with our legal advisors, the external legal advisors, and eventually we came to the conclusion it is better we settle the disputes, because at the family level, between the Hinduja group level as well as the Sumitomo family level, there is a strong bond. Then why we did not take that opportunity to settle it rather than fighting? Sumitomo is a giant $110 billion business group. So therefore, they are in all range of businesses. So this is something in our mind all the time. Now that brings me to second point in my discussions. We believe in a dispute resolution policy. In a large business group with 90,000 people, if you don't have a dispute resolution policy, then definitely there will be problems. And as I said, there are 10 business verticals. We manufacture automobile, we run banks, we produce car lubricants, we run one of the largest BPOs in the world, we run power stations, we are in oil, gas, energy, media, entertainment. So you name it and we are there. So in such an event, unless and until there is a properly drafted dispute resolution policy, it is not possible for any large business group like us to manage. I may be the general counsel of the entire group, but it does not mean that I am really competent or I have got the time to look into on a daily basis what is happening where within the group. So we need a dispute resolution policy. And we have got a dispute resolution policy. Sum and substance of this is that, you will be surprised, don't get into dispute. That is the sum and substance. So therefore, we try to prevent the disputes from happening through the dispute resolution policy rather than describe in a very narrative way when a dispute happens, then how do you manage? And that is where I was just thinking when I was listening to Maria, that it's really she stole all of my words. This is precisely what we do all the time. And thank you, Maria, for supporting me in that. So therefore, prevention is always better than cure, but it is an art. She talked about the settlement. So when you find out a dispute is happening, and how you can find that out? If you have got a very good dispute resolution policy, which will educate the people around the world, as far as we are concerned, to try to find out the symptoms. Dispute is a symptom. Dispute is not a disease. So I try to always educate them by telling, try to pick up the body language, maybe of your customers, maybe of your partners, maybe of your joint venture partners, maybe of your potential business friends. Try to find out the body language. And then if you sense, if you smell that a dispute is going to happen, then you please look into my dispute resolution policy. Where you have to escalate. And in many cases, we have gone up to the level of the promoters level, because our promoters, as Richard also says, is politically very well connected. So therefore, when there is a need to settle it by talking to really the people who mattered, we did it. Very recently, we had a big dispute with Fiat. And Fiat subsidiary Iveco was our partner for 17 long years in our automotive business. And we fall apart, the marriage went sour, and then we started fighting with each other. During that time also, the matter did not go at the level of the promoters. I thought that why can I not bring it to the attention of the promoters, because both the Fiat Angelo family and Hindujas, they have got good relationships at some level. So friends, what I'm trying to figure out is that, what I'm trying to emphasize, that the whole emphasis is nothing but prevention. But prevention is not possible only through dispute resolution policy. For prevention, I always say, and I always try to quote unquote educate my colleagues around the world, look at your contract. The drafting, the dreadful drafting is something which gives you all the headache. So at the primary level, when you are entering into the contract, at that point of time itself, you see that how you can prevent it by putting proper clauses. And now that's a challenge, because yes, I am a part of the decision-making process in the group. Most of the time I am available in the business meetings. But then sometimes it becomes quite embarrassing when very recently the president of Nigeria. He came to this country and he had a business meeting with us, and eventually I was asked, Abhijit, can you prepare a two-pager? I said, that's problem. I can prepare a two-pager only with one condition, that it is not legally binding. So naturally, all hell broke loose. What you are talking of, it's a great photo opportunity. So therefore, if you come and say it is not legally binding, then what happens? I said that do not sign something in haste and then very leisurely you regret what you have signed. Please don't do that. Best thing is that if you want photo ops, if you want to have an MOU with a foreign government, by all means, please go ahead and do it. But then don't make it as a legally binding and create more problem for all of us. You can always say that the parties within a particular period of time will go ahead and prepare the legally binding definitive agreements. You can always do it. And trust me, my friends, this is one way of preventing the disputes. Because when we sign joint venture contract, it is always hunky-dory, honey, and if you come there and say, as general counsel, but I feel it is a problem. Oh, you don't know. I think we are all great friends, actually. Why do you perceive even that there is something likely to happen? It will never happen. That is where the role of the general counsel, and Maria also very correctly said, the role of the external counsels are very, very important. I'm now coming to the fourth point in my discussion. When you have got the opportunity to settle, and this is one point Maria has very eloquently stated this, please try to settle. When I run a litigation, which is not that frequent, I must admit, and I'm quite excited because I have just won a case against one of the largest companies on earth based in Germany. So I'm quite excited to tell that even in those cases also, we try to settle when the dispute is on. Before approaching to the court, whether I am sued or I am suing, there is one thing we always keep it in our mind, that is it really worthwhile to push it up to the level of the court or arbitration, or can we settle it? Because in a business, there is nothing called, sitting on prestige. That's why in a large group, when you have got multiple people, and in the dispute resolution policy, if you say, this is how you are escalating the dispute. So when it comes to my table, the actual body chemistry which was not matching at the lower level, that particular gentleman or that particular lady, she or he is out. Because she or he is not the decision-making authority. It has already reached my table. If it reaches my table, then it will reach the table of the chairman of the group. Or in some cases, it will reach the table of the board of directors and at their meeting. So therefore, we take a very compassionate view and we try to see, can we settle something? For every dispute, mind that we have got a legal strategy. I do not deal with any dispute, potential dispute, future dispute, past dispute, unless and until I have developed a proper legal strategy. This strategy will give us the direction how we are going to handle it. I just told you that we have just won this case. Honestly speaking, I did not want to win this case. It's a very nasty case. But eventually, I tried to settle it at different level. Finally, I approached the promoters and say that, look, can you talk to this particular company CEO? And finally, they also tried, it failed. Then we all became very wild and we said there is no other option but to fight it out in the court. So while the court process was going on, still we tried to settle. So as a legal strategy, we forced this company to come to the negotiating table and then finally settle it. And yes, we settled that. So settlement is the core of our heart. Let me come to the sixth point in my discussion. How do we manage the dispute? Now, this is basically quite a challenging one. As I said that you have to prioritize your litigation, dispute, settlement, whatever you say. I always do some kind of ABC analysis that the value of the dispute may not be large, but relationship may be more important, or the value of the dispute also may be very large. So based on that, you categorize into A, B, and C analysis. and then you concentrate, you develop your legal strategy. Recently, I won a case in Estonia. It has gone into the laws journal because it was a 4-year long dispute over my IPR, and whom I was fighting the Russian mafia. And when I used to go to Tallinn, I was told that better you stay indoor rather than roaming around and trying to discuss with your lawyers, etc. Eventually, we, through different strategies, after involving our own businesses, we settled the dispute. But before settlement, first we won the dispute. And then, do you know what I did? In terms of settlement, we bought over the company, which was troubling us in the IPR. So, friends, I think there are different varieties of strategies that you have to develop. When I see the forum, I'm not inclined to talk about how do you manage your dispute. You should have your resources and you should have the proper external counsel. Now, external counsel itself, I need at least one day session to tell you what kind of external counsels are being appointed, how they are being managed. My one-liner to them when I engage, and I engage them all over the world, and some of them are the biggest in the world, but I tell them only one thing. Please act as my own legal department. You are an extended arm of the legal department. If you don't keep this in mind, then I'm sorry, you are out. So therefore, the moment you align to my philosophy that you are an extended arm of my legal department, you will take care of my cost, you will take care of my time, you will take care of finally the interest. So it's a very vast subject, as Richard was also mentioning at the beginning. So therefore, I will stop here. My one-line take will be, don't get into dispute. I know it's a bad news for the law firms, but if you try to avoid it, better go in for the settlement. And eventually, if you can't settle, courts are all there. Let's go and fight it out, but through a legal strategy. Thank you very much.